Right. Well, you may ask why I'm sitting here with a funny face on. Well, that's because I want everybody to enjoy themselves. And if I start off the talk with a smile, um, we might carry on with a smile. Now, I'll just come back to normal again now. Magic. All right. Um, well, I've decided that what I'm going to do is to give a talk about advocacy, not to be a definitive study of advocacy or indeed an authority on how you should do it. I mean, I'm 72 years of age, been a criminal uh, legal aid solicitor uh, most of my life, up to about 50, and then I was made a district judge, and I sat as recorder for a bit. I was a High Court advocate. Anyway, so I thought what I would do, because I've given these talks now at a couple of university meetings, they've gone down reasonably well. And of course, being 72 at the moment, I remember my name and where I live. And of course, as anybody knows of my age and older, and as we approach my age, the memory begins to get a bit shaky. And although it is even shaky now, there are still bits I remember. So, what I intend to do is ramble through what I think advocacy is about, designed especially for students, really, or the newly qualified, because obviously it's once you get past 3 or 5 years, you tend to slowly find your feet, and of course training's different as well. Different colleges, different art, different pupilages, different art training contracts, and so on, as to how it goes. Um, well, dealing with me, I have extensive knowledge, I would suggest, in the magistrates' court, some experience in the Crown Court as a higher court advocate. I also think I was either the first or the second high court advocate to ever been appointed. I was then appointed a district judge, magistrates' court, and eventually a Crown Court recorder. I was also, whilst doing that job, a prison adjudicator. I did some childcare work as well. Now, when I qualified early 70s, you were not given advocacy training as a solicitor. Um, it wasn't part of the course. You just learnt it as you went along. And the bar, of course, in those days had pupilages, and obviously advocacy was an emphasis for them, but for solicitors it wasn't. And so basically, I learnt it by just watching and making mistakes. I mean, it took me ages to understand what leading question was, and if somebody said to me, "You're leading," I'd say, I'll try to change it and lead again because I didn't know what a leading question was. So I'm going to try and do this in a series of, say, 15, 20-minute talks. And I invite any experienced advocates that are watching this that think I've got it wrong, or they think that they can add a bit, or even a constructive criticism. Do so in the comments, or add a link to something you've done yourselves. I mean, it's only really meant to be perhaps my opinion of what I did and what I think is important. Um, so let's start with what I feel is important. Well, I think the impression is you give us an advocate, it's got to be a visual integrity. You've got to look that you're a man of integrity and reliability. You've got to speak with clarity and pace and timing to emphasize what you want to say in the areas where a pause or pregnant pause is important. Right, solicitors. Let's start with them. Well, I suppose solicitors start their advocacy, unlike the bar, which starts with a brief. Their advocacy you start in the police station, because if the advocate attends the police station, then he will think in terms of the courtroom, and of course that's often the issue when you get non-advocates tending the police station. I'm not saying that's wrong, because that's the nature of the way things are, but clearly an advocate attending the police station or customs interview, or whichever interview it may be, will have his mind on the courtroom at all times. So therefore, whether you answer questions, how you answer questions, how the client answers questions. Guilty pleas, of course, early admissions, give credit. Not guilty plea, not sure, what do you do? If you're not answering questions, record why you're not answering questions, becomes important later on. Anyway, I'm not going to discuss the law in relation to police interviews because I'm out of date now, to be frank. I've been retired now for about 8 years, so in terms of law, you'll have to bear with me in respect to that. I don't have access to legal authorities anymore. I could have really done a lot better if I did have, but anyway, I haven't. So, just dealing with the police station, of course, sometimes you get a badly behaved investigating officer. It looks very good to your client for you to correct him, but sometimes that bad behaviour may be evidence that may become relevant to a later court case. I just say that in passing because you need to really have your mind on the court case at all time. Right. Now, I'm going to finish at the very beginning. How you dress. Now, do not go into court like that because they will all think that you're not going to be worth listening to, and they'd be right, wouldn't they? So, let's see how I can illustrate about how you're dressed. I think nowadays there's a lot more latitude in how you can dress, but I would still suggest that you dressed conventionally. If you're dressing flamboyantly, and some advocates do dress flamboyantly to try and exhibit their kind of presence and their personality. I'm not saying that's the wrong thing to do. I think that's fine. If they get away with it, that's good. But really, you've got to not upset by your dress the person that's listening to what you have to say. And of course, historically, the quorum, judge or magistrates tend to be, always have been, in the past or could well be. I've got to be careful how you phrase it in these day and age. But of course, of an older age group. So anyway, let's see if I give an example of me. I was appearing in the Crown Court as a High Court advocate, and a QC was in the same case, and of course, being a member of the bar, they all talk like that. What? I know, I'm sure I'm going to get some responses from the members of the bar now in respect to my barrister impersonation. Anyway, he said to me, he said, "Dear Trevor," he said, if I was sitting in the Crown Court, he said, I would not recognise you. And I said, "Why is that?" Because I was robed and I had a blue and white tunic shirt. And he said to me, he said, I wouldn't recognise you. He said, because there's clearly more blue than white in your striped shirt. Now, that actually happened. And I suspect it was of its time. I don't suppose it would happen now. But he was sitting as a judge in the Crown Court as recorded at the time, see, and he would have been upset with my blue and white striped shirt, which would have undermined my appearance in front of him, I suspect. So you've got to think like that. Now, for the female members of the profession, I obviously can't comment very much on that, except that I do think the attire that most lady barristers would be wearing would not be what they choose to wear on a night out. I'm not going to say much more about that, except that I do think somewhere in the back of my memory somewhere, there was a barrister that took the Inland Revenue to court to get tax relief on the clothing that she had to buy for court, saying it was like a professional attire and it should be tax deductible. I don't know what the result of that was, but to anybody to whom it's relevant, it might be worth looking at. Maybe somebody who knows the answer can stick a comment on down below. Right, next thing sounds pretty obvious. Hygiene, shouldn't need much talking about it. But I was a cyclist in London. I used to cycle to and from court, and I was a legal aid lawyer, single parent at that time, very short of money, and so I used to I found it best to cycle to get around London, but also I used to choose my clothing from charity shops. So I used to leave in various cells in those days, in the courts, a spare set, and I'd arrive on bicycle, and I went to Boots the chemist, and I got some. They had cucumber flavoured wet wipes in a big tub, and I used to go down the cells, change, because of course it was a bit hot and sticky. I'd mop myself off and cool myself down and clean myself up. And of course, when I'd go into court, the benefit of those standing around me had the benefit of fragrant cucumbers, and on occasion people said they were very hungry. But anyway, what I'm trying to say is that being smelling of a cucumber is fine. Smelling of anything that is adverse is not so fine. So travelling through London, that kind of thing, bicycles, because a lot of people do cycle now, all need to be thought out in terms of hygiene. But that's all part of advocacy. And of course, what I'm trying to do is I'm trying to cover things that aren't in a book or course on advocacy. Now, I'm restricted in that the only book on advocacy I've ever known about was the one I wrote as a booklet in about 1985, and that was when I was 5 years qualified, and really reflected the mistakes I'd made at the time. So I don't really know what the current books on advocacy say, nor do I know what the current courses on advocacy say. So obviously, if you're a young person and you're about to launch your career, and I say something in contradiction to what the course says, and obviously, the course is designed for it, whereas I might be wrong. So that's what you need to think about. All right. Now, your first 2 days, or your first court case, first, second or third court case, it's fair to say the anxiety level will be high. How do you deal with it? Well, stress is a good and bad thing. Adrenaline in advocacy will run. It will happen. There are some that after a few years you don't get so stressful and you don't get so anxious. But certainly when you start, you probably will do. I think I did. I remember. But I do know this: the better prepared you are, first of all, the better you'll do in the court case, and secondly, you're more chance of enjoying what you are doing. But of course, the famous story is true, is that the quality of the case counts. So, for instance, if you've got a good case, in other words, you've got a really good factual case legally as well, then you're going to look good. If you've got a case which has got a lot of problems in it, then you're going to struggle, aren't you? But the idea of it is to look as if you're not struggling, and making a case as good as it can be. Right, well, I think now I've been talking about 15-20 minutes now. I will stop and I will then do this in sections. So this will be part 1.